if the defendant used that defendant's youth, regardless of how old he was or whether he was over or under the age of consent, if she used that youth and his status as being younger than her or a teenager in order to be able to exploit that victim or use that difference in age to be able to accomplish the crime, then OB-10 can be scored. Again, abuse of authority status can also justify the scoring of OB-10 where that authority status is used as a means of committing a crime. In this case, again, under a preponderance standard, the court finds, number one, the defendant was in a position of authority over the victim in this case. I think it's more likely than not that she used that authority status, the ability to grant or deny privileges as part of her role at Shalano. And then I do think there's sufficient evidence reading through the PSI that she used the victim's youth, his willingness to engage in this kind of conduct. She took advantage of that to satisfy her own sexual urges in this case. So the court finds that she did exploit his youth, the difference in their age, that she did exploit her authority status more likely than not. And therefore, the court finds there's sufficient facts to support a scoring vote 10 points, and the court will deny that challenge. Next one.
Thank you, Your Honor. OB-13, continuing a pattern of criminal behavior that requires 3 continuous acts. I'm not certain what those acts are. She indicated that nothing occurred more than twice, and he indicated less than that. So that there's nothing factual in the record to support three separate acts for the continued pattern.
So, reading from the PSI, where it says page 3 on the bottom, I'm just going to read the whole thing. She said she and EB had sex at least twice. She said they had sex in a cleaning closet. She worked a float position so she could move around. EB would manufacture a crisis, such as flooding a toilet, and she would have to go to the cleaning closet. While in the closet, she would face the door so she could watch for other employees. She would take down her pants and underwear and bend over for the intercourse. She confirmed it was penis vaginal. She said the last time it happened, he came inside her. She purchased a Plan B, but it did not work. When asked about oral sex, she said he went down on her for a few seconds, but she performed oral sex on him just before they had intercourse the last time. When I read that, there's at least 2 incidents of penetration. There's 2 different types of oral sex. Each of those is a separate type of crime, and all of them would count for OB-13. I think it was scored properly. Thank you.
All right, again, OB-13 applies to a continuing pattern of criminal behavior. In this case, it's scored at 25 points. And that is where the offense was part of a pattern of felonious criminal activity involving 3 or more crimes against a person. In this case, I read the PSI. I read it the same way the prosecutor did, which was there were at least 2 instances of vaginal intercourse, as well as 1 instance of the victim performing oral sex on the defendant and the defendant performing oral sex on the victim. Those crimes all need to occur within 5 years. It's clear this all occurred in a short period of time. Again, looking at this under the standard, the court finds there's a sufficient factual basis to conclude that there were 3 or more sexual penetrations, felonious sexual penetrations that occurred. So the court will deny that challenge. Sure. What you said there were
yeah, but I'm not going to challenge OB-19 based off of the record so far. So I'm going to withdraw that challenge. I would ask the court to maybe reconsider after the victim speaks OB-10, but I'll just raise that for the record, and then that's the entirety of my challenges.
Okay. All right. Thank you. Ms. Coe, do the people have any additions, deletions, or corrections?
No, Your Honor.
I did receive an impact statement earlier today. Have a chance to review that statement.
And I think victim EB should be on Zoom. He was moved last week, so we were chasing him around to multiple different people trying to get him here, but I think he's here. And I think Miss Rios may also be present. She is the minor child's mother. She may want to speak. She was deciding today.
All right, Ms. Rios, I see we have brought you into this hearing. If you wish to make a statement, did you wish to do that today?
Your Honor, sorry, is this the victim's mom?
It is.
I thought it was the victim. Can I just make the proper objection for it?
Let me find out if she wants to speak
Okay,
first.
all right.
Ms. Rios, did you wish to make a statement today?
Yes.
Okay, 1 second, please, Mr.
Your Honor, I would just object under the statute itself. It allows for the victim to speak, and it also allows for a family member to speak if the victim's under 18, but to speak for the victim. But in this instance, the victim is speaking, so that it wouldn't be applicable. That I would just make that objection.
Your Honor, I believe, and I'd have to pull the exact spot in the statute. I actually went over this numerous times. Because he is a minor, the parents are considered victims. Because he is incarcerated, he didn't have rights until sentencing. So we didn't provide those rights, but we did work with his mother. I actually ended up calling the Prosecutors Association because everywhere in the Crime Victim Act, it talks about defendants being incarcerated, but not victims. So minor victims, I should say. So we treated both of them as victims throughout the whole case.
So my reading of the Crime Victims' Rights Act is that under these circumstances, both the victim, because he's a minor, would be able to make a statement along with a parent. I think there is an added layer here that the victim is currently incarcerated. I think all of that together, it's the court's ruling today that both or either can make statements. So the court will deny the objection. And Ms. Rios, now would be your time. Can you just, I already know this, but I want to make a record of it. You're the mother of the victim in this case, is that correct?
Yes, Your Honor.
Okay, and you may have heard this when I brought you in and made this statement at the beginning of the case here, but I'm just going to ask that you refrain from using your child's name here on the record, okay?
Okay.
And that's to protect his privacy. So please let me know whatever it is that you would like to state. I did read through your written statement that you submitted as well.
Okay.
All right, let's talk about that. This continued sentencing hearing in People v. Jennifer Palmer brought us into even more sobering territory, with Judge George Mertz presiding over a case that's as emotionally fraught as it is legally intricate. We were deep into the phase of sentencing variable challenges, specifically AV-10 and AV-13, both of which carry significant weight in Michigan's felony sentencing guidelines. And the court's analysis here was methodical, grounded, and given. The facts inescapably tough. Let's start with OV-10, exploitation of a vulnerable victim. Judge Mertz made it clear that the score was sticking. His reasoning? Even if the 16-year-old victim was technically of legal age under Michigan's consent laws, Palmer's position as a juvenile detention officer meant she wielded power over the youth's movement, phone access, and privileges. And it wasn't just the institutional control. The court also found that she took advantage of the victim's youth and naivete to satisfy her own sexual desires. The legal threshold is preponderance of the evidence, more likely than not, and Judge Mertz didn't mince words. Palmer's actions, in both abusing her authority and exploiting the teen's vulnerability, hit that mark. Then came AV-13, which requires a pattern of 3 or more felonious acts. The defense tried to argue there wasn't enough to meet that standard, pointing out that Palmer claimed the acts didn't happen more than twice. But the PSI told a different story. According to it, there were multiple forms of sexual contact. At least 2 instances of vaginal intercourse, and 2 types of oral sex, each of which constitutes a separate felony-level offense. Judge Mertz counted them up, stayed within the 5-year time frame, and denied the challenge. In his words, there were 3 or more felonious sexual penetrations. Simple, clear, and definitive. After the guideline debates wrapped, the court turned to the victims. The courtroom took a pause when it became clear both the minor victim, identified only by initials, and his mother were set to speak. The defense objected to the mother's statement, citing that the statute allows a parent to speak only if the victim is under 18 and not already addressing the court. But the prosecution argued that because the victim was both a minor and incarcerated, the court had treated both the youth and his mother as victims throughout the process. Judge Mertz ultimately ruled in favor of allowing both to speak, stating this was in line with the spirit, and arguably the letter of the Crime Victims' Rights Act. The mood in the courtroom at that point was heavy. It wasn't just a sentencing, it was a reckoning. The judge's tone never veered into sensationalism, and the attorneys, despite their disagreements, remained professional and focused. But you could feel the weight of it, the power imbalance, the betrayal of trust, the lifelong consequences hanging in the air. Judge Mertz made clear he wasn't just calculating numbers. He was weighing conduct, character, and the broader implications of the offense. This was courtroom justice, stripped of theatrics, just truth, process, and consequences delivered with care. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.